Well, hello and welcome back to another exciting edition of Coffee with Stephen. So, this week's blog is entitled You Have the Right to Babble Incoherently. And it was not what I had originally planned on writing about. As I was setting up my ideas for what the blog would be this week, I happened to go on YouTube and those little YouTube shorts that appear on your feed. There was one by an individual, a gun rights influencer, I guess you would say, who stated somewhat emphatically that if the police were not to read you your Miranda warning, that it would preclude a district attorney from filing charges against you. And then he offered the advice that you want to begin querying the law enforcement officer, thereby, I guess, throwing him off his game and preventing him from remembering that he has to Mirandize you. This is worse than bad legal advice. It's just wrong, okay? And it does show a fundamental misunderstanding of what the Mirandize admonishment is all about. More importantly, it did sort of create the genesis for also wanting to look at some of what I would consider to be the problematic aspects of suppression of evidence. So first off, and you can read about this obviously in the blog, but the first thing that I want to make sure is absolutely understood. Just because law enforcement fails to Mirandize you does not mean that somehow the district attorney cannot file a case. Quite the opposite, actually. If you fail to make any statements after the failure of a Mirandizing, then there's nothing that is going to be suppressed. Okay, all it does is act as a prophylactic that would keep that evidence from being used at trial. They may not need your testimony in order to secure a conviction. If there are numerous witnesses, if there's video footage, anything that you say might be considered to be almost superfluous. So it doesn't automatically negate these things. Anyways, I go through a somewhat lengthy analysis and show some various hypotheticals within the blog. I do advise you to read it. It might give you a greater understanding of how the Miranda warning is actually set up. And then, like I said, it sort of like compares our adversarial system, where we do suppress illegally obtained evidence, with an inquisitorial system where that evidence all still comes in. There may still be a claim that the defendant can file against the law enforcement officer, arguably from his jail cell for violating his civil rights. But a greater question sort of manifests, and that is, if you have a law-abiding citizen and they are subject to an illegal search, there really isn't any sort of recourse for a violation of their civil rights. After all, the cops searched them and they didn't find anything, all right? There is nothing to suppress. On the other hand, if the individual is a criminal, factual criminal, meaning they were in possession of illegal contraband and an illegal search occurred, then that evidence is suppressed. So ultimately speaking, this entire system of evidentiary exclusion literally only benefits the criminal. And as, the late Justice Benjamin Cardoza once opined, the constable blunders and the defendant goes free. So is this really how we want a society to operate, where we reintroduce potentially dangerous criminals into society because of a constable's blunder, and really offer no recourse to law-abiding citizens whose civil rights have been violated? Anyways, I do hope that you read the blog, as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.